If you think the battle's won, think again. The fact is, for each one we reach, there's one we can't. And if we can't reach them, chances are nobody can. Because a mind is a terrible thing to waste.
Loved ones of Breonna Taylor grieving and outraged. The 26-year-old Louisville first responder shot 8 times and killed by police. Police reports say officers Jonathan Mattingly, Brett Hankinson, and Miles Cosgrove, wearing plain clothes and no body cameras, announced themselves and forced entry.
The officers forced entry into the exterior door and were immediately met by gunfire.
But in a new wrongful death lawsuit against the officers, Taylor's family says they never announced themselves.
Police raid a home on Detroit's west side, turning the place upside down, searching for illegal drugs.
But the homeowner says that the officers targeted the wrong house.
I'm a known wanted felon for drugs. I'm 22 years, I'm 20 to 25. I'm 54.
1.5 story dwelling, red brick, gold trim, and siding on the front.
That's the front, that's the house next door.
The FBI is investigating the Little Rock Police Department, looking into how they conducted searches using the so-called No Knock Warrants.
He said that initial call came in just as dozens of other people in the city were stepping forward, each complaining that the LRPD barged into their homes unannounced, often with bogus information.
But in the black and brown community, this has been happening for decades.
I don't trust being in my own home near that home because I don't know if someone's going to knock down my door and shoot my dogs and kill me and my husband and kill me and my husband and kill me and my husband.
Picture this. Work has ended. You're on your way home. You make it home and your spouse has cooked dinner. You tell each other about your day, you eat, and then head upstairs to get ready for bed. You fall asleep 20 minutes after laying down. 3 hours later, you're awakened to a loud boom downstairs. You reach for your gun and you tell your spouse to stay in bed. Upon seeing strangers in your home, you immediately start shooting and the strangers shoot back, hitting your spouse, and then you fall to the floor, only to realize that these were plainclothes police officers who have fled the scene and later come to arrest you. Breonna Taylor was an essential worker in the city of Louisville, Kentucky when this happened to her. The Fourth Amendment to the Constitution of the United States states, and I quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized." Oftentimes, the average American believes that his or her constitutional rights prohibit law enforcement from entering their place of business or their private residence without prior notification. I am here to tell you today that that is not the case. Let's get into it. Webster's 1828 dictionary defines the verb definition of the word warrant as to authorize, to give authority or power to do or forbear anything by which the person authorized is secured or saved harmless from any loss or damage by the act. That same dictionary also defines the noun definition of warrant as an act, instrument, or obligation by which one person authorizes another to do something which he has not otherwise a right to do. An act or instrument investing one with the right or authority and thus securing him from loss or damage, a word of general application. A no-knock warrant is a search authorization allowing law enforcement officers to access specific properties or premises without knocking, publicizing their existence, or purpose for entering a specific premise. It appears that the first of the no-knock laws were signed into law at the behest of President Richard Nixon's administration in 1970. According to the 1970 almanac, Congress had approved 2 laws. the Drug Abuse Prevention and Control Act, and the District of Columbia Court Reform and Criminal Procedure Act. The latter of the two laws contained authority for federal agents to conduct searches of private dwellings under certain circumstances without first knocking and identifying themselves. In arguing for such no-knock warrant authority, advocates emphasize the swiftness with which evidence, in particular evidence of narcotics sale or use, could be destroyed if the persons engaged in the drug transaction were notified that law enforcement agents were on the scene. Opponents of no-knock argued that it was a violation of the Fourth Amendment guarantee that citizens be protected from unreasonable searches or seizures, a guarantee enforced by the requirement that searches usually had to be authorized by a search warrant issued by a federal magistrate or judge. As you can see, even back then, this law was met with much controversy. A Democrat by the name of Senator Samuel J. Ervin Jr. was a visible and vocal critic of the Nixon administration. An article from the 1974 CQ Almanac states, and I quote, "The 1970 no-knock statutes had been enacted in a period of hysteria," Ervin said, "when people were afraid of rising crime rates. We ought not to sacrifice on the altar of doubt and fear what is the proud boast of our law, that every man's home is his castle. The Bill of Rights," he said, "applies to everyone, even drug peddlers." Under the 1970 drug abuse law, enforcement officers were permitted to make no-knock entries in narcotic cases if the judge or magistrate issuing the warrant found probable cause to believe that the property sought would be destroyed or someone's life or safety endangered if notice were given. The 1970 D.C. Crime Control Law authorized no-knock search and arrest warrants if there was probable cause to believe that notice was likely to result in destruction of evidence sought, danger to the life and safety of the policeman or another person, escape of the party to be arrested, or where such notice would be a useless gesture. Officers could make no-knock entries without such authorization in the warrant if they found the specified circumstances after obtaining the warrant. In describing the legal effects of his repeal amendment, Ervin said future searches by federal narcotic agents would be subject to the general requirements applicable to all federal law enforcement officers. Namely, the officer must give notice of his purpose and authority prior to entering to execute a warrant, and to any judicially recognized exceptions or applications of the statutory requirement. The amendment also made D.C. police subject to the general requirements applicable to federal law enforcement officers. The amendment repealed a provision of D.C. law that exempted from the notice requirements police officers who obtain entry by means of a trick or stratagem. And it repealed another provision which made it a specific crime to destroy or conceal evidence sought under a search warrant. Ervin said such action was punishable under several laws. Ervin and other supporters of no-knock repeal cited a statement by District of Columbia Police Chief Jerry Wilson, quoted in the Washington Post June 8, that he would not oppose repeal of the D.C. no-knock provision. "It won't affect us one way or another," Wilson said, adding that the D.C. police had not used no-knock warrants since October 1971. While federal narcotic agents once used no-knock authority regularly, Ervin cited figures indicating that only one federal no-knock warrant was used in the past year. The Drug Enforcement Administration had issued new guidelines for no-knock warrants following an April 1973 incident in which federal agents mistakenly raided the homes of two innocent families in Collegeville, Illinois. Opposition to no-knock repeal was led by Roman L. Ruska, who said 39 states used no-knock laws and the Supreme Court had developed case law that justified unannounced entries in certain situations. The federal no-knock law has been used sparingly and with discretion that is scored in its favor, Haruska said. He also said that no-knock warrant provisions interposed the magistrate between the police and door of the accused, thus providing greater protection for the rights of individuals that if the police were permitted to make no-knock entries without judicial authorization. Huruska inserted in the Congressional Record a letter from Attorney General William B. Saxby saying that the Justice Department opposed elimination of the statutory federal no-knock authority. Saxby said it was not clear whether Irvin Nelson amendment would reinstate the common law exceptions to the rule requiring an announcement before entry. The potential for abuses of this authority is no greater than the potential abuse of all authority vested in federal law enforcement officers, Saxby wrote. The effective deterrent to abuse is a combination of responsible administration and continuing oversight by the Congress rather than the abolition of the authority itself. End quote. The article goes on further to state, led by Senator Sam J. Ervin Jr., the opponents inserted the repeal provision in S. 3355 when it came to the Senate floor in July. The Senate version, approved July 11th by an 89-0 vote, also contained language barring U.S. aid to any country which allowed the production of opium poppies. This language was aimed at Turkey, which announced July 1 that it was rescinding a 1971 ban on poppy cultivation. The Senate bill contained a total authorization for the Drug Administration of $900 million for fiscal 1975 through 1979. The House-passed bill was narrower, providing authorizations totaling $480 million for fiscal years 1975 through 1977. The House version, approved by voice vote on August 5th, repealed the no-knock provision of the 1970 drug law, but not the District of Columbia drug law. It did not contain the provision cutting off aid to poppy-producing countries. As signed into law on October 26, 1974, Senate Bill S. 3355 authorized appropriations up to $105 million for fiscal 1975, $175 million for fiscal 1976, and $200 million for fiscal 1977 for the Drug Enforcement Administration. It repealed the provisions of the 1970 Drug Abuse Prevention and Control Act and the 1970 District of Columbia Court Reform and Criminal Procedure Act, which allowed federal or district agents to make no-knock entries in certain circumstances. It amended the 1970 Drug Act to provide that parole guidelines would apply to persons convicted and sentenced under any of the federal drug laws repealed by the 1970 law. It also made it a federal crime to kill an agent of the Drug Enforcement Administration. The repeal of no-knock laws was short-lived. The Anti-Drug Abuse Act of 1986 reintroduced no-knock laws and quick-knock laws under President Ronald Reagan's administration.